Can a man be sexually harassed at work? The Supreme Court said yes, and that's exactly what happened to Joseph Oncale, a young oil rig worker who never imagined his story would reach the Supreme Court, but it did, and the outcome changed workplace protections in a way that still matters today. By the end of this video, you'll have a clear understanding of the laws that protect all employees from harassment, regardless of gender. You'll also learn how certain workplace cultures and leadership failures can actually enable abusers and silence victims. And most importantly, you're going to walk away knowing how to speak up, even when the odds feel against you. Hi, I'm Harlow Reed, employment lawyer, HR consultant, and creator of the HR Insider. And on this channel, I do more than share my legal opinion. I break down real legal cases to show you how the law might apply to your situation. Over the last couple of weeks, I've been focused on the topic of harassment at work, and for good reason. It's an important but such a complicated subject. And I've covered a few really incredible stories about cases involving women. If you haven't already, I recommend watching my videos on Lois Jensen and Ellen Pio. Lois Jensen's case was the first class action sexual harassment lawsuit in the United States, and it exposed just how brutal the workplace can be for women in male-dominated industries. Ellen Pio's story is different, but just as compelling. It's about gender discrimination in pay and workplace practices, and it really highlights how gender bias can show up in subtle ways, like pay disparities and unequal access to leadership opportunities. Both stories are powerful and deeply thought-provoking. They reveal the real-world impact of workplace discrimination, and they help set the stage for why conversations like the one we're having today about harassment and its effect on everyone are so important. But today I am starting something new, a series on harassment and its impact on men. It's a topic that's talked about far less often, but that doesn't make it any less important. This series isn't about speaking for men. It's about sharing facts, real cases, and insights to help anyone better understand how harassment laws apply, regardless of gender. And of course, I'll be offering my professional perspective along the way. So let's talk about it. The content on this channel is for informational purposes only and shouldn't be taken as legal advice. Always consult a qualified attorney or HR professional for guidance on your specific situation. And hey, don't forget to like and subscribe. This story begins with Joseph Oncale, who at 21 years old began working at Sundowner Offshore Services on an offshore oil rig in August of 1991. He was hired to work as a roustabout on an 8-man crew in the Gulf of Mexico. A roustabout is an entry-level worker, and Joseph was responsible for physically demanding tasks like moving equipment, assisting drillers, and maintaining the rig. This was the lowest-ranking crew member on a tough, all-male oil rig where physical labor was expected and speaking out or doing things against the norm carried consequences. Oncale was placed on an 8-man crew working in the Gulf of Mexico, and among his coworkers were John Lyons, the crane operator, and Danny Pippin, who was the driller, both of whom had supervisory authority. Another crew member named Brandon Johnson was also a part of the team, and while working with his team, Oncale notified Human Resources that on several occasions he was subjected to sexually humiliating acts by his coworkers. He said the Lyons and Pippin physically assaulted him in a sexual manner, and Lyons also threatened to rape him, all in the presence of the rest of the crew. And he said this happened often, it happened repeatedly. He said that they were aggressive and that every time it happened, it was intended to humiliate him. To really understand Joseph Oncale's experience, you have to step into the world of offshore oil rig work in the early 1990s. This was a male-dominated, physically demanding industry. It was built on toughness, built on endurance, and most of all, silence. Crews worked long hours in isolated conditions, sometimes days or weeks at a time. They had very little privacy and nowhere to go if things went wrong. The environment was harsh, not just in the work itself, but in the culture. Rough language, hazing, crude humor, these were all part of the daily norm when you worked in this environment. And for someone in Oncale's position, a young entry-level worker with no real power, no real experience, pushing back against that culture came with real risk. And reporting harassment in that kind of environment wasn't just difficult, it was almost unthinkable. There was an unspoken rule. You deal with the consequences, you deal with the environment. You don't ever talk about it, and you never complain. So when Onkel came forward and reported what was happening, he wasn't just breaking the silence, he was challenging a system, a culture, a norm that had tolerated this type of behavior for years. But Joseph Oncale didn't stay silent. He reported the harassment to human resources, hoping the company would take action to stop the harassing behavior. But instead of finding support, he learned something that made it even worse. Valant Hohen, the company's safety compliance clerk, admitted that Lyons and Pippin picked on him. Valant, this safety compliance clerk, they picked on him too. And Onkel sensed that he was up against a losing battle when someone in a safety and compliance position had experienced similar mistreatment, and yet nothing was done. And to make matters worse, at the time this happened to Joseph Oncale, the courts didn't even agree on whether Title VII, the federal law that prohibits workplace harassment, applied to situations where the harassment came from someone of the same sex. And that's what makes this case so important. It helps establish something that still isn't talked about enough today. Men are protected too. Title VII doesn't just apply to women, it applies to everyone. And that includes men, whether they're being harassed by women or by other men. The law is about behavior, not identity, and no one should be forced to endure humiliation or threats at work, no matter who they are. Learn more about who the law protects and how harassment laws apply in real workplaces. Check out my video, Workplace Harassment Prevention Training: How to Stop Bullying, Discrimination, and Retaliation. This is a full federal anti harassment training video that breaks it all down in plain language, including what counts as harassment, how to report it, and what your employer is legally required to do. And if you live in California, Illinois, or New York, I've also created state specific training videos for employees in those states as well, because each has unique requirements that go beyond federal law. You'll find links to all of these videos in the description below or right here on the channel under the harassment training playlist. Okay, back to Onkel v. Sundowner offshore. Despite red flags, no investigation was open, no consequences were issued, and no protection was offered to Joseph Onkel. So he was left with no real options and decided to resign because it became clear to him that nothing would change. But Onkel didn't just walk away quietly. He formally told the company that he was leaving because of the sexual harassment and verbal abuse. When the case went to trial, Onkel testified that he genuinely feared being raped by one or more of the men on his crew. And in that hostile environment, he believed that no one would step in to stop it. So he made it clear to Sundowner that his resignation wasn't voluntary. It was the result of a hostile environment that the company had failed to stop. If there's one common theme in the stories where the employee actually prevails, it's this: they made the employer aware of what was happening. I encourage people, employees, to report concerns to human resources and to get it on record. Even if you end up leaving the company, you need to be able to show that you acted in good faith, because leaving and then suing without ever giving your employer a chance to fix it can be seen as bad faith. You have to give your employer an opportunity to correct the issue. That's part of building a strong case. And more importantly, it's the right thing to do. Let's not forget, Joseph Oncale resigned in November of 1991, and his case didn't even make it to the court until March of 1995. And the final decision from the Supreme Court, that didn't come until March 4th of 1998. I hope you're counting, because that's 7 years to get justice. If you've seen any of my other videos, you know that pointing out the timeline is something that I do often. And I do that because taking your employer to court is the long game. And that's not to say that it's not worth it. If your rights have been violated, absolutely speak up. That's what we should all do. But you've got to be ready for the process. Justice doesn't happen overnight. So if you decide to leave your job because of harassment or discrimination, document it, report it, and do the right thing now, so that if you ever need to take legal action, you're protected. In 98, the Supreme Court ruled in a unanimous decision that same sex harassment is actionable under Title VII. Justice Scalia wrote the opinion, and a quote from the court was Title VII prohibition of discrimination because of sex protects men and women. But the court didn't award damages or make a final decision about what happened. They sent the case back to the lower court to be reviewed under this new legal standard. So, what happened after that? Well, we don't know for sure. Many cases settle privately once the legal groundwork is laid, but the impact of this decision was already historic. It expanded federal protection to everyone, regardless of who the harasser is. Now, if you were working in the 90s, you probably remember how different the workplace culture was then. But here's why this case still matters, especially if you're mid career and have responsibilities that others rely on. Harassment is about power. It's not about gender. It doesn't matter if the harasser is male or female. The law looks at the behavior of the person, not the identity. You don't have to prove romantic intent either. It's not about sexuality. It's about whether the behavior created a hostile work environment because of sex. The law doesn't favor one gender. It protects all employees from sex based mistreatment. This means that men are protected as well. But the truth is, a lot of men stay silent, but they're not alone. I've worked with people who said nothing for years because they didn't think anyone would believe them or they worried it would make them look weak. But once they understood their rights, they realized they had more power than they thought. Employers must investigate. Regardless of gender, companies have a duty to take all harassment claims seriously, no matter who reports it. So, if you've ever told yourself, I'm probably just being too sensitive or no one's going to take this seriously, this case proves otherwise. At this point in your career, you've probably seen a lot. Maybe you've stayed quiet when you shouldn't have, or maybe you've watched it happen to someone else. Whatever your experience, you are not powerless, and this channel is here to help. So, drop a comment if this content speaks to you, or if you've ever faced something like this at work. And be sure to subscribe because this is just the first in our new series on men and workplace rights. And trust me, we've got more stories that are worth telling. Thanks for watching today. I'll see you in the next video.